Back on In Focus tonight, Newzroom Afrika channel 405, and conversations continue now. Public Protector Advocate Busisiwe Mkhwebane could soon face 2 criminal charges of perjury. This is in relation to her conduct during a judicial review of her 2017-2018 investigation into the South African Reserve Bank's bailout of apartheid bank Bankorp. Now, the bailout took place between 1985 and 1991. To unpack further this story and the developments in the story, I'm now joined by Advocate Hoffman, Director at Accountability Now. Good to have you with us, Advocate, and thank you very much for your time. Of course, the Public Protector has not been successful in her attempt to have the perjury charges against her withdrawn. This you were alerted and made aware of by the NPA, saying now they are going to go ahead. Will this matter, in your view, be finalized before the expiry of the 7-year term of the Public Protector in 2023? And is it important that it is finalized before then?
Good evening, Taba, and good evening to your viewers. Thank you for the opportunity. The trouble with all the cases against the Public Protector, and this is not the only one, the perjury charges came first. There was a complaint that she is not a fit and proper person to be an advocate, which the Legal Practice Council has been sitting on. And then, of course, there is her impeachment before the National Assembly, which is a convoluted and new procedure. In fact, it's the first case of its kind that has ever happened in South Africa. And she has adopted the Stalingrad strategy in respect of all of the cases against her. She made representations to persuade the National Prosecuting Authority to withdraw the charges that it initiated against her on a complaint from Accountability Now. She seems to have got the Legal Practice Council keeping the matter on the back burner, and she has litigated uphill and down dale with Parliament, right to the extreme of asking the self-same constitutional court that said that the impeachment hearing can go ahead to reconsider its position on that. She's also likely to be, or viable to be, suspended by the President while all of these problems are swirling around her head. But her attitude seems to be that if she can string this lot out to the end of her term of office, then she will. So, yes, the criminal charges should be expedited and they should be dealt with as soon as possible. But let's be realistic. There will be appeals, there will be delays, there will be every opportunity taken to spin the matter out, because that's the way the Public Protector has been operating all along since her appointment.
Any indication from the NPA as to why her representations lacked merit in this particular case? And is there opportunity there to review that decision of the NPA?
No, that has come and gone. What happened on Monday this week is that we received a letter from the National Director of Public Prosecutions, who said that she had rejected the request in respect of the 2 charges that are still on the table, and that she is satisfied that there are reasonable prospects of success in the matter. So her review of the decision of the Director of Public Prosecutions has come down in favor of the prosecution continuing, and that is what will happen. We have written back and said, thank you very much. See if you can expedite this case, because if this case is brought to a satisfactory conviction soon, then clearly the Public Protector will not be able to continue in office, because it's quite difficult to run a Chapter 9 institution in orange overalls from inside a jail.
Yeah. The Public Protector previously was of the view that the NPA is not ready for trial, saying even as the matters were currently continuing, they were still interviewing people, continuing with some investigations. In your view, has enough or significant movement now being made in the case to go to trial, and you're confident that it will be successful?
Yes, I'm sure that the matter can be made trial ready in a short space of time. The basis of the perjury charges is the finding of the Constitutional Court in the matter that you mentioned in the intro. The attempt by the Public Protector, really quite strange, to get Parliament to change the mandate of the Reserve Bank, and her conversion of a complaint against the State Security Agency in the New South Africa into an order that Absa Bank repay money from a transaction that occurred in the old South Africa. So how she managed to contrive to do that is quite a remarkable feat that has very little to do with the application of her mandate or the enforcement of the law.
Now, there's been, of course, a debate around this particular issue. You've mentioned a number of legal matters that are facing the public protector, the impeachment, as it were, this particular case, and a number of other challenges to her reports. Considering the politics that have been such a key factor in her tenure, does a decision like impeaching her or finding her guilty of perjury not set a bad precedent for, I suppose, future public protectors who come into this office when people are unhappy with their findings, that they will take them to court and back and come back with all sorts of things just to distract or even disrupt the public protector from doing their work?
The complaint is not related to unhappiness with the findings. The complaint is related to the fact that this public protector seems to be incompetent and lacks the integrity that is required of a person who holds that high office. I agree with you that the politics so the optics of the politics are certainly muddying the water. She was initially treated as royal game by the ANC, so that when before all of this happened, before she even committed perjury, we had complained as Accountability Now and as the complainant to the public protector about the CIEX matter. We complained to her oversight body, the Justice Portfolio Committee in Parliament, as long ago as January 2017, that she seemed not to understand how to do her job and that she had lied to us in email correspondence. And we put it to her that that was what was going on. And she said, no, well, she was going to run her office her way and not Tuli Madonsela's way, and that she wasn't prepared to investigate herself in relation to the lying in the correspondence. And we said, we don't want you to investigate yourself. We want you to account for telling us that there's no preliminary report in the matter, when in fact there is a preliminary report which is signed by you and sent to President Zuma. And she seemed not to be prepared to deal with it herself, and she was protected by the majority in the in the Justice Portfolio Committee, as a consequence of which the Justice Portfolio Committee has simply never, ever dealt with the matter at all. They have not ever asked her to answer the questions that were put to her by us back in 2017. And that is why the matter is dragged on and turned into a criminal case. And it all could have been nipped in the bud in January 2017 if she had been made to explain why she said there was no preliminary report in the CIX matter when there was one, and why she wasn't involving the complainant in the preliminary report consideration stage of the matter, which had always been done by all of the public protectors who had preceded her in office.
Advocate
she's the author of her own misfortune.
Advocate, I appreciate your time. Thank you very much for coming through tonight. Director of Accountability Now, Advocate Paul Hoffman there.